I'm Jeffrey Rosen, President and CEO of the National Constitution Center. A few years ago, learning about the forgotten meaning of the pursuit of happiness changed my life. When the founders wrote that famous phrase in the Declaration of Independence, they meant an ongoing commitment to self-improvement and lifelong learning. This discovery inspired me to write a book, and in my new podcast, I explore the founders' lives with the historians who know them best. Plus, filmmaker Ken Burns shares his daily practice of self-reflection. Join me for Pursuit, the Founder's Guide to Happiness. Listen to Pursuit, the Founder's Guide to Happiness on your favorite podcast app. On September 23rd, Jimmy Kimmel returned to the airwaves after his late-night show was suspended for nearly a week. Hello, friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. This week, we'll discuss the recent Jimmy Kimmel suspension, as well as the broader history and constitutionality of jawboning. That's the practice of government officials pressuring private actors to stifle speech. To help us unpack this important topic, we have two of the leading scholars on both jawboning and free speech. Genevieve Lakier is professor of law and Marjorie Freed teaching scholar at the University of Chicago Law School. She's written extensively on the dangers of jawboning, including her forthcoming article, Enforcing the First Amendment in an Era of Jawboning, which is coming out in the University of Chicago Law Review. Genevieve, it's wonderful to welcome you back to We the People.
Wonderful to be here, if under difficult circumstances, perhaps, for free speech.
Indeed. And Eugene Volokh is Thomas M. Siebel Senior Fellow at the Hoover Institution, and Gary T. Schwartz, Distinguished Professor of Law Emeritus at UCLA Law School, a preeminent First Amendment scholar. He's published articles and books on a wide range of free speech issues, including jawboning, and is the founder and co-author of the Volokh Conspiracy, a leading legal blog. Eugene, it's always wonderful to welcome you back to We the People.
Always glad to be on.
Well, let's jump right in. Genevieve, in a recent interview in Wired magazine, you said that Brendan Carr's threats against ABC appear to be a pretty clear case of jawboning, and you've added that the Supreme Court has made clear that that's unconstitutional in all circumstances. What is jawboning, and why is Brendan Carr's threats a pretty clear case of it?
Well, jawboning, as you explained very nicely, very succinctly in the intro, is when government officials use their own bully pulpit, use their voice or some other mechanism to threaten nominally private actors, in this case ABC and its affiliates, with some kind of harm unless they suppress either their own speech or the speech of someone else. The Supreme Court has made very clear last year in a unanimous decision in a case called NRA v. Volokh that the First Amendment prohibits this kind of behavior whenever it is intended to suppress speech. So there could be, I guess, government officials could say things that have the effect of leading private actors to think, oh, I should stop speaking. But that isn't a violation of the Constitution. But if you are intentionally attempting to suppress speech by threatening sanctions against the speaker or the institution that hosts it, then that's unconstitutional coercion. And it violates the First Amendment. And in the Volokh case, the Supreme Court in a 9-0 decision said that the rule is categorical. You don't do interest balancing. You don't ask, is there some compelling reason the government had to do this? This is completely anathema to the First Amendment because essentially what the government official is trying to do in that moment is evade the constraints on their power that are imposed by the First Amendment. They're saying, look, I don't have to pass a law. I don't have to take official action to suppress your speech that could be subject to court order. I'm just going to threaten you. And by using the threat, I'm going to lead you to suppress your own speech. So we never need to get to the difficult situation where I have to actually coerce or officially enforce some kind of mandate and a court could supervise it. Jawboning is really dangerous from a First Amendment perspective because often what will happen, and I think we saw here before there was the massive public backlash, corporations like ABC, if they are threatened by a powerful government official, will often just comply with the threat rather than saying, no, make me. And then forcing there to be some kind of formal confrontation in which a court could get involved. They'll just comply and suppress speech and we will all be the loser. Now, the reason why I thought that this was a pretty clear-cut case of jawboning is because this kind of unconstitutional or informal coercion often happens in secret. You pick up a phone, you have a backdoor meeting, no one ever finds out about it. But Carr said on a podcast very bluntly that he, and in the midst of a conversation about how he had been pushing to revive the public interest standard that the FCC employs when deciding what stations can get licenses, that ABC had to do something about Kimmel or the FCC would have more work in front of it. And so although it's not an explicit threat, he didn't say, if ABC doesn't take down Kimmel's show, we will take away the licenses of their affiliates. The standard from Volokh is if you take any action that reasonably conveys the threat of adverse government action in order to suppress speech, you have violated the Constitution. And this seems clearly to satisfy that standard.
Thank you so much for that. Eugene, on the same day, September 18th, you wrote in the Volokh Conspiracy in a piece, Jimmy Kimmel, the NRA, and the First Amendment, that although ABC is free to suspend Jimmy Kimmel's show for whatever reason it wants to, if the government coerced ABC into suspending the show through threats of retaliation, that would likely have violated the First Amendment. And you say we know that because of NRA v. Volokh and also the Murthy decision decided the same year. Tell us more about your conclusion.
Well, hard to say much more because Genevieve said it all. That case is pretty squarely on point. In both cases, the government is going after a business that's an intermediary in a sense. In NRA v. Volokh was insurance companies that were providing various services and engaging in business deals with the National Rifle Association. And there, the allegation was that New York was pressuring them to cut off or reduce those ties because it disapproved of the NRA's politics. Here, it's the FCC or the FCC chairman pressuring networks to cut off Jimmy Kimmel's show. So it's pretty squarely on point. One interesting thing to keep in mind is not only is this an example of kind of a conservative precedent being used to defend a liberal speaker, oversimplify here, but basically that. It was pretty clear that that would happen. And in fact, the NRA v. Volokh case was argued by David Cole, who was the national legal director of the ACLU. Now, there was pushback within the ACLU when the ACLU agreed to represent the NRA. Two, at least, chapters publicly disagreed with that and disavowed that position. But I think the ACLU's position, besides just sort of, I think, general principles that all speech deserves protection, is also that, a precedent that is set on behalf of conservatives today may help liberals tomorrow and vice versa. And I think David Cole has been vindicated here, and the ACLU was too. That I think I'm hoping that many on the left now see the value of promoting these kinds of precedents and building these kinds of left-right coalitions. I'm pleased to say that Ted Cruz, of course, a very conservative Texas senator, spoke out against Carr's position. And one of the things he expressly said is, look, I think it's right to condemn it, but in any event, conservatives should really worry about the FCC using this power to go after the left, because then they'll use the power to go after the right in the future. So I wish more people saw things the way David Cole and the ACLU did and the way that Ted Cruz did, which is that it's important to protect both sides in order to help protect your side eventually, whichever side it may be.
It is indeed. And Jimmy Kimmel, in his statement earlier this week, thanked not only Ted Cruz, but also Rand Paul and a series of other conservatives, Mitch McConnell, for standing up for free speech on a bipartisan basis. Genevieve, in your forthcoming article on jawboning, enforcing the First Amendment in an era of jawboning, you argue that the court in Volokh seemed to be straightforwardly applying a case called Bantam Books, but in fact, it represents a decisive rejection of a significant body of lower court precedent that read these principles much more narrowly and formalistically over the past 60 years. Tell us more about Bantam Books and the road from Bantam to Volokh.
Yeah, great. Actually, this picks up a little bit on Eugene's earlier comments about bipartisan commitment to pushing back against jawboning, because I have also been very pleased by the response to the Kimmel suspension, which I thought was a pretty blatant and shocking example of how powerful government coercion can be. But I haven't always found there to be bipartisan consensus. I think this is only the latest in many instances of troubling jawboning under the Trump administration that I have been saddened that conservatives who often align themselves with free speech have not been publicly opposed to. And then similarly, under the Biden administration, I think that there was plenty of jawboning, less perhaps public in some cases, and maybe less overt. But I do think that there is always this tricky question. You know, we all say we love free speech, but it is so much easier to love free speech when it is your side, that is being targeted for speech suppression. And in fact, if we look at the history of sort of modern regulation of speech in the US, I think what we see is an epidemic of jawboning, or rather, I guess, a pandemic, that there has been government officials have used this tactic going back basically since the emergence of the modern First Amendment. Prior to the emergence of the modern First Amendment, you didn't really have to use informal threats. I'm assuming that they were still used, but it wasn't so important because the First Amendment didn't impose very significant constraints on government power. But since then, since the 1930s and 1940s, when we started to see the modern, very strong First Amendment, we have seen continuous efforts by government officials to evade it. And then on the part of scholars and politicians and others, I think there's always been anxiety about how much you bring courts to bear to constrain this kind of informal speech regulation, because I think there is this view among many that jawboning is just how you get stuff done. Often, that one of the things that government officials do is that they put pressure on private companies to act in the best interest of the country as they see it. And sort of that's necessary to keep everyone in line. And so I think often there is a lot of uncertainty about where we should draw the line between what is just the government wheedling, pushing, persuading private companies to act differently, and the government violating the law. And so this is, I think, what led to decades of lower courts being very uncertain about what the rule should be when it comes to jawboning. So, as you said, in 1963, the court, in a very important decision called Bantam Books v. Sullivan, articulates for the first time the First Amendment rule against jawboning. Essentially, the idea that we hear again in the Volokh case, that as a government official, if you intentionally act to suppress speech by making threats of harm against the speaker or the speech intermediary, you're violating the First Amendment. You know, but it's the first opinion. It's not exactly clear how much they're making a general rule. They're just saying in the circumstances of the case, which were pretty egregious. It was a state commission on morality that sends booksellers a list of books that they think are inappropriate to be sold to minors. But these are books, many of which are not technically obscene or unprotected under the prevailing First Amendment precedents. And then they follow that up they send police officers to the local book retailers to check if they've taken the books down. I mean, this is very heavy-handed pressure. And the court says this violates the First Amendment, which was a significant achievement at the time because lower courts were not sure. There was no clear rule at the time. So the court establishes that rule. But in the decades after Bantam Books, there is disarray in the lower courts because they're not sure whether the rule against jawboning only applies when it comes to such heavy-handed pressure as the Bantam Books case involved. You have police officers. You are threatening criminal prosecution. You are basically ordering booksellers to take down a very specific list of books. Does that qualify as jawboning? In the Third Circuit, in the DC Circuit, in the 11th Circuit, this is essentially what the lower courts hold. Or does jawboning apply anytime a government official uses any threat of government power, whether it is criminal prosecution or the loss of benefits or not approving a merger, anything like that, in order to suppress speech? And that was much closer to the rule in the 7th Circuit and the 2nd Circuit. And the 9th Circuit, I think, was very uncertain about what it was doing. And Volokh affirms that it is a broad rule. We're not going to ask, is this very strong pressure or medium pressure or light pressure? We're just going to ask, are you intending to use the threat of adverse government action in order to suppress speech? And if so, it's unconstitutional. And so I think the Volokh court recognized that this is a very dangerous practice no matter how it is carried out. And I think it could not have come at a better time, because what we are seeing all around us is many, many instances of government officials trying to evade the very, very important constraints the First Amendment imposes on their ability to push private speakers around by jawboning.
Eugene, in a dissenting opinion in the Murthy case, Justice Alito argued that the court's standard for traceability was unduly stringent and a departure from prior precedent. He said that officials who read today's decision today with Volokh will get the message if a coercive campaign is carried with enough sophistication, it may get by. That's not the message the court should send. Is there a division among the justices of the Robert Court about the standard for jawboning? And tell us more broadly what power the FCC does have, either under the public interest standard that Chairman Carr is trying to resurrect or the now abandoned fairness doctrine to put economic pressure on media companies.
Yeah, so first, I think in Murthy, which was a companion case to NRA v. Volokh, though it had a different bottom line result, the real dispute was about what had to be shown as a practical matter in a typical case to show that the jawboning actually caused the restriction. Because after all, sometimes the government asks or even demands something that the intermediary would have done in any event. There may have been business pressure on the intermediary to do that. Often the business pressure stems from the same kind of political concerns, political writ large, as the government's pressure. So there was some evidence that social media platforms were acting in large part because they were enforcing their own rules having to do with COVID-related speech, for example, and that the court ultimately concluded that there wasn't enough evidence that to allow the particular remedies that the plaintiff sought, that this all was traceable to the government's actions. It's very important when you're litigating this, but the big picture remains that coercive threats are a First Amendment violation. Sometimes you might not be able to bring the case to court or to prevail in court on that, but the First Amendment does not allow them. And I hope the political process, when it's functioning properly, will fault government officials who engage in such threats, whether or not eventually years down the line, those threats could lead to a judicially enforceable award or a judicial injunction. Now, there's a separate question, though, you asked, which is a very important question, is what can the FCC do with regard to broadcasters? And for a combination of functional and historical reasons, the Supreme Court has allowed the government to have more authority over broadcasting, over-the-air broadcasting, than over newspaper publishing, book publishing, the internet, even cable television is actually more protected than broadcast television. The government early on instituted a licensing system for broadcasting, which of course clearly couldn't have, say, for newspapers. The licensing was justified by the need to prevent electromagnetic spectrum interference, where if two people are broadcasting the same frequency, then perhaps neither will be heard. But once there was this licensing system, then there was this view that the licenses, because of the scarcity of spectrum space, were themselves scarce, so themselves a kind of a government-issued benefit, and the government could attach conditions to that benefit. So one condition that was imposed was, as you pointed out, the fairness doctrine, which was eventually abolished by the FCC in 1987, but upheld earlier by the U.S. Supreme Court in 1969 in a case called Red Line Broadcasting. And that required broadcasters to, I oversimplify here, but basically to provide airtime to rival views when they provided airtime to some view on a political issue. There was relatedly a personal attack rule, which allowed people who were personally criticized on broadcasting time to respond. And of course, famously, in a case about 10 years later, the court also upheld the ban on the 7 dirty words on broadcasting, something that also is unconstitutional as to newspapers or even as to speech in public. So there are these different rules. At the same time, the Supreme Court has always made clear that they provide the government some extra authority over broadcasting, but limited authority. So, for example, there is the news distortion doctrine that the FCC has applied, never came to the U.S. Supreme Court, but might be constitutional to impose fines, for example, if there is misinformation and disinformation, to use the modern terms, on broadcasting. It has been applied really very rarely and very narrowly. I'm told by a colleague it's been applied only once in the last 40 years, in quite an unusual case. And in any event, it quite clearly wouldn't justify suspending an entire TV show. So even if Brendan Carr had reason to think that Jimmy Kimmel's statements were news distortion and thus potentially actionable by the FCC, I don't think the government can use the threat of suspending a license and such to leverage that one-time relatively minor violation into a demand to suspend the entire show going forward.
Genevieve, in your article, you praise the Volokh court's muscular reassertion of a categorical rule against constitutional evasion, but you also say that a court-centered approach to jawboning is ultimately insufficient to protect free expression, given the reluctance of people to file suit and the inability of courts to keep up with the claims. Tell us why a court-centered approach is insufficient and what a different approach might look like.
Okay, well, I think there are at least two different aspects to the problem here. And this follows nicely from what Eugene was just talking about. So there's just, I think, a doctrinal problem, which makes it hard for courts to play the vigorous role that I think Volokh envisages them playing in defending us all against this kind of speech suppression. And that is the standing problem. As Murthy illustrates, I mean, I think the doubleheader of Volokh and Murthy, both of which were very important decisions, long-awaited decisions, handed down in the same term, but they communicate a very different message. Volokh says, no jawboning ever. We're 9-0 on this. We're very strongly committed to this rule. Murthy says, but standing is going to be hard to prove, especially if you're not the corporation that is directly targeted. You're not ABC or you're not Meta. You're not the social media company that the government is directly pressuring. You're just the speaker whose speech happens to be suppressed. You're just Jimmy Kimmel, whose show is now off the airwaves. We might think that this is the person who First Amendment doctrine cares the most about, right? This is the actual speaker. It's not just the company that is hosting or facilitating the speech. But that person will often not have much information about what actually went down. What did the executives in the C-suite at ABC, what were they actually saying when they decided to suspend the show? What was Meta thinking when it was hearing these complaints from the Biden administration about what it was doing vis-a-vis COVID misinformation? And so when you as a plaintiff get into court, and the speaker is usually the one who's bringing the suit because they have the most to lose and the least to gain from the jawboning, right? Because jawboning always entails it's a threat, but it's also a promise on the other side. Listen, we're going to do bad things to you if you don't comply, but we're going to maintain business as usual, maybe even give you benefits, you company, you speech intermediary, if you do comply. So it's the speaker that usually is the one that comes to court the most to challenge this, and they have very limited information. They cannot prove often with the evidence that they have available to them, well, there was actually the government's threats that caused the harm. And this was precisely the problem in Murthy, not the only problem. I think there were numerous problems with that decision and how it was pled and decided that made this a very easy case to strike down on standing grounds. But even in cases where there isn't, perhaps we might worry about politically motivated litigation occurring, sprawling and perhaps undisciplined claims and facts that I think, as the Supreme Court makes clear, the lower courts were not doing a good job patrolling. There were lots and lots of problems with the Murthy case as it proceeded through the courts that made it easy to strike down on standing grounds. We just know that many jawboning cases get struck down for this reason. They don't even make it through motion to dismiss. And so that means that it may well often be the case that there is very effective jawboning occurring, and there's no one who's going to come to court to defend, who can defend the First Amendment rights, both their own and all of ours, against it. And so that's one reason why I don't think courts can play the role they need to play. And I would suggest we need to rethink our standing rules in these contexts. We need to have a broader conception of standing in jawboning cases than the court in Murthy articulated. But that's a doctrinal problem. I think a very significant one, but a doctrinal problem. The second goes to the second half of what Eugene said, which is the sort of just the nature of government power in a heavily regulated society. I agree 100% with Eugene that if the FCC tried to deny a license to an ABC-affiliated network station on a public interest basis when these denials are on a distortion. They try to use some doctrine that they rarely used in the past in order to punish the station. I think it would be pretty clear that that's retaliation, and that would be a violation of the First Amendment. They could bring suit. But, if ABC doesn't get approval on its next merger, or if the FCC launches an investigation into race discrimination in the hiring practices of these networks, or if it does something, it just makes their, re-upping their station license harder. It requires them to jump through more hoops. I think that would all be very hard to bring to court and, get a retaliation victory against. The government officials, especially an administration that seems pretty unified in terms of identifying its enemies and going after them, can find many routes to punish speakers and companies that defy their orders. You can think about it like water going through a sieve. There's going to find some way of exercising government power. And so I think it is a problem. It is a structural problem. Right now, like in the wake of the car incident, I do think that First Amendment scholars and others need to think about where and how discretion over speech exists in the existing regulatory framework. The public interest standard has always been a very broad and amorphous standard, and it gives FCC commissioners a tremendous amount of power. And there has been a long history of FCC using that power to push and prod television broadcasters. And maybe that power needs to be cabined or constrained in some way, not through case-by-case litigation, you jawboned here, or you jawboned here, but we need to impose more constraints on how you wield the power, who determines what is or is not in the public interest to prevent the jawboning in the first place. Because I do worry that if we're only depending upon litigants being able to get into court and then win a court case and then get damages or remedies of some sort, that's insufficient.
Eugene, as Genevieve says, there's a long history of the FCC and the government imposing economic pressure on mergers, for example, and just as CBS settled because its eagerness to get a merger through under the Trump administration, so Democratic administrations delayed or put pressure on proposed mergers of Fox and of Rupert Murdoch. In a response to Genevieve and her co-author Evelyn Dueck, who wrote a piece called Lochner.com, in the Harvard Law Review, you have a piece called Free Speech and Private Power, and you say that there may be room for First Amendment doctrine that constrains some non-coercive interactions between the government and private entities. What kind of non-coercive interactions do you have in mind, and what kind of doctrinal or regulatory tools might limit them? Sure.
So here where I think we're getting to a different thing, although also a thing that has at times been called jawboning. So far we've been talking about basically coercive threats. If you want this particular deal to be approved by our administration, you need to restrict this speech on your network, on your social media platform, whatever else. And I do think that at least as a formal legal matter, setting aside the difficulties of enforcement, NRA v. Volokh says that that is unconstitutional. But what if the government isn't being coercive? Now, one possibility is, it's saying it's not being coercive, but we all know that there's coercive pressure. But let's say that it isn't coercive at all. Let's say it's just trying to urge private entities to restrict speech. And that was, in fact, part of the allegation in Murphy v. Missouri. Part of it was that the government was coercing them, but partly it was just kind of really talking hard at them. That's one possible meaning of jawboning, kind of really trying to persuade them, kind of nag them into restricting certain kinds of speech. So here's one possible answer. That's not coercion. That's just the government speaking. It's the government itself expressing its views, using its bully pulpit, not in the modern bully sense of throwing its weight around in a coercive way, but I think in the older sense that it was kind of a prominent pulpit to urge people to do the right thing and to restrict certain kinds of speech. Here's an example, which I think not terribly controversial. Somebody, or maybe it's controversial among some, but I think descriptively most people would agree with it. Somebody calls up the newspaper. Somebody calls, let's say, from the State Department and says, "You're about to publish this article about how we're negotiating some treaty or whatever else. And look, we know we can't stop you. And We're not trying to threaten you. You're the New York Times. You know exactly what you're allowed to do. You are allowed to do this. But let me just tell you, if you do this, this is going to totally interfere with this possibly very valuable treaty making. And can you see your way clear at not publishing that? Or if you don't want the foreign policy dimension, it could be a police chief in town calling up the newspaper and saying, look, you're about to publish this article. It's going to interfere with law enforcement. Again, we won't retaliate against you if you do that. It's just, wouldn't you feel bad? Wouldn't your subscribers maybe be upset with you for that? Or another thing, speaking of misinformation, is somebody calls up a newspaper and says, you're about to publish this article. It's all bunk. And let me show you why it's bunk. And if you publish it, not only would it be bad for me, that's why I'm calling you, it would be bad for your reputation, bad for your readers. He may even say, look, you called me up, left me a message asking for my comment. This is my comment. You should not run this article because it's false. That could be a valuable public service. At the same time, the question arises, what happens if this is done in an organized enough way, in a systematic enough way, perhaps, that the government is sort of working out a public-private partnership to restrict speech about the election, about COVID, about various things, maybe for laudable purposes, maybe not. And so here's the analogy that I give. And it's only an analogy. It's not squarely on point. That's why it's an analogy. But I happen to own some rental properties. And if the police call me up and say, look, Volokh, first, we're not trying to coerce you. If you want to say no, that's perfectly fine. People say no to us all the time. We understand this. But, we're having hard... we think one of your tenants is committing some crimes. We don't have enough to get a warrant. But we happen to know that under your lease, you have the power with some 48 hours notice, let's say, to go and inspect the property just to make sure that there aren't code violations or that there aren't unauthorized people living there or whatever else. We know that you have the power to do that. It wouldn't even be illegal for you to do that. Certainly not unconstitutional because you're a private entity. So why don't you do that? And in the process, just look around and then tell us what you find. Turns out that generally speaking, lower courts say that makes my search into something governed by the Fourth Amendment. And maybe I could be sued under the Fourth Amendment for that, even though I'm a private entity and normally not bound by the Fourth Amendment. But I could be because I'm in cahoots with the government, and that evidence can be excluded in any prosecution because it was obtained in violation of the Fourth Amendment. No coercion. It's just persuasion. It's just a request that I, as an intermediary, as a private entity, do something that, absent this request, I would have every right to do. But that, the court says, it's the lower courts, which have mostly developed this doctrine, but in light of Supreme Court precedent, that gives too much authority to the government. That if the government can combine its coercive power over citizens that can arrest them and such, with the non-coercive, but much broader in many ways, private power of private property owners, broader just because they aren't usually constrained by the Fourth Amendment and they have access to their private property, that combination is just too powerful, too dangerous, and therefore we need to use the Fourth Amendment to police those kinds of governmental requests for what would otherwise be only a private search. So maybe there should be something similar to that with regard to speech, when the government again is jawboning just in the sense of talking and persuading and trying to come up with a system of this kind of public-private partnership. Maybe not, but that's one of the really interesting questions that NRA v. Volokh doesn't answer because that wasn't the issue in NRA v. Volokh, and Murthy didn't answer because of the standing holding of the court.
Genevieve, what do you think of some of the examples Eugene gave, including the possibility of a Fourth Amendment search? And more broadly, you've said that jawboning is the great underappreciated free speech problem in the American tradition. Tell us about its history, which includes the federal government pressuring private speech intermediaries sometimes to boost favored speech rather than taking down disfavored speech. You give the example of President Nixon pressuring the networks at the end of his time in office because there wasn't enough favorable coverage. And given the fact that you think the law is underdeveloped, how do you think it might productively develop in the future?
Well, I think Eugene's idea of having some kind of wall of separation between the government and private speech intermediaries, we might think maybe not everybody, but corporations that have a very significant role to play. They're a node in our system of free expression. If you're a network or a social media company or a newspaper, you are controlling access to all different kinds of speech to many different people. So having some kind of rule that you don't need to prove coercion, we're just going to have a categorical bar against any, I guess, content-related conversations between government officials and these private entities. I think that's interesting because, in fact, often in these situations, particularly when you have repeat players, you have corporations that have very well-established relationships with government regulators, you might think they actually don't need to have threats to communicate their purpose, right? Like it might, in fact, often be coercive. The wonderful judge, David Bazelon, wrote a wonderful article about what he called a raised eyebrow coercion or raised eyebrow campaigns by the FCC, in which he really was talking about conversations between FCC commissioners and networks where they would just raise their eyebrow, like, is that such a good idea, really? And that communicated, given the FCC's power over licenses, a tremendous amount to the recipient. That might be hard in court to prove that that's coercive. All you did was raise your eyebrow. What are you talking about? And so a rule that just says, nope, we're going to cut off communication altogether between certain important players would alleviate the network or the speaker or whoever from having to prove that the raised eyebrow actually is constitutionally significant, which would be a kind of fun thing to try and argue in court, but maybe not the best way to defend our system of constitutional democracy. So there are advantages. Now, I guess I would say it is interesting then that we have, the courts so far have rejected such a rule. In fact, in Bantam Books, the case I talked about earlier, the original jawboning case in the Supreme Court in 1963, a writers' organization wrote an amicus brief that they submitted to the court in which they suggested a per se rule. They said that any blacklist, any list of books that's submitted by a government official, a policeman, a prosecutor, a state official, to a bookseller that lists books that, in their opinion, are should not be disseminated, violates the Constitution, violates the First Amendment. You don't have to prove intent. You don't have to prove coercion. That blacklist is unconstitutional, and the court does not agree. Wants a narrow rule. And I think what that reflects, and I think the same would probably be true today, because Eugene noted earlier that the Volokh case was quite controversial, even among First Amendment scholars. And it was not just controversial because it was the NRA, and so it was scrambling sort of partisan loyalties, but also because I think there was a significant portion of First Amendment scholars and others who worried that too strong a reaffirmation of an anti-jawboning rule, imposing too many constraints on the government's ability to use its bully pulpit, would impede effective regulation of what are often incredibly important and rich and powerful corporations that are making choices all the time. And maybe we want to empower Biden to tell Facebook it is killing people. And maybe we want to empower the mayor to tell the local bookseller that it's conducting its business poorly, because maybe that's the only way to impose a kind of public interest concern on these important private businesses. This is, of course, the motivation behind the public interest standard we've been talking about when it comes to the broadcast networks. And I think it informs a lot of the conversation about jawboning, where on one side, there's this worry that, the government is using this all the time to suppress speech. But then there are lots of people who are worried that if we overreact, if we correct too far, we're going to impede all kinds of effective regulation. And so I do think that there is this sort of first order question about which is the greater harm. Is it more of a harm to our system of free expression to limit the government's ability to convey information, even when it might be helpful? The FBI might have really useful information about the posts you're allowing on your social media platform, Facebook, or Brennan Carr may have really important understandings of the liability that teens are going to be, addicted to bad substances if you run these ads. So on the one hand, there's that class of concerns. We might think that there are important regulatory interests that are being promoted by communication. And on the other hand, there's this risk to the system of free expression. One of the things I try and show in the article is that we should not undercount the risk of jawboning. That there's a long history of jawboning, that it is broad and deep. We have evidence of officials, local officials, state level officials, federal officials. We have evidence of executive branch officials, legislative officials, you name it, using whatever tools are at their disposal when it is in their interest or some kind of political, there's a political motivation behind it, to lean on private businesses to get them to suppress their speech. So I am generally in favor of a broader jawboning rule because I think we don't appreciate, because so much of it is secret and so little of it has come to the courts, how very significant a free speech problem this is. But of course, it is difficult to, figure out the balance of the costs and the benefits when you're dealing with a practice that is by its very nature intended to evade our understanding, right? The whole point, the jawboning works by seeping into the cracks in the system. Much of it is going to be very hard to see. And so we're just guessing. I do my best in the paper to chronicle those instances of jawboning that are illustrative and that we know about because they actually did make it to the courts, or there was Watergate and there was all of a sudden a lot of information that was previously unknown about the inner workings of the White House. But ordinarily, we just don't know what we don't know. And so it is a significant problem. How significant a problem it is very hard to tell. But I think that should lead us to be willing to commit to a broader constraint on government power. But there are regulatory costs.
Eugene, any final thoughts, if you have them, on the question of jawboning and the networks? And then let's turn to the question of the universities. You have argued that while the government has discretion in issuing grants, it can't withhold funding or tax-exempt status based on disfavored viewpoints because this limits the university's right to free speech, and free expression in the university context is fundamental. Tell us about how to analyze the questions involving President Trump and universities and whether the jawboning cases are relevant or not.
Right. So it's complicated. And it's complicated for a variety of reasons. So one is we know that the government can attach conditions to government funds. Now, those conditions are often attached by Congress, and there may be non-First Amendment reasons. There may be reasons related to separation of powers or just the text of a statute that limit the president's ability to throw in extra ones or to enforce them in ways that are contrary to the congressional enforcement scheme. But let's set that aside for now, just because we're talking about the First Amendment. The government can say, look, this is our money. We want to make sure that it's used in ways that promote our goals. And of course, that is the premise of Title VI of the Civil Rights Act of 1964, of the Title IX amendments, that look, if you want to get money, federal funds for education, well, you can't discriminate based on race or sex or national origin. That's as a condition of that government funding. So likewise, the government can, for example, say, look, at least consistently with the First Amendment, can say, look, if we think that you are tolerating anti-Semitism on campus and anti-Semitic activity, like, for example, as was alleged and was found by a federal judge at my own former university, UCLA, that UCLA was tolerating an exclusion of Jews or Israelis or pro-Israel students from particular part of campus by the encampers who had taken over that part. Yeah, the government can attach that as a condition, can enforce that as a condition on government funds. I would think also, again, setting aside the question whether federal statutes authorize it, but in federal government could say, look, if you want our funds, you need to make sure that you prevent disruption generally on campus. And if you don't enforce your own rules having to do with not allowing people to take over parts of campus for days on end, then, we think you're going to be poor stewards of this federal money. That's not a First Amendment problem. On the other hand, I do think if the government says, look, as a condition of getting this money, you have to promise not to allow racist speech on campus, or anti-Semitic speech, or sexist or anti-gay speech, or whatever else. You have to promise not to allow it by students. You have to promise not to allow it by faculty. That's a viewpoint-based condition to a general government benefit program that the government generally cannot impose. That's one reason, for example, why I have long criticized, attempts by the government. They started, in some measure, I think, during the Obama administration, continued it as the anti-Israel speech under the Biden administration, and now, of course, have been even more used by the Trump administration. Attempts to require private universities to impose campus speech codes against supposedly harassing speech that creates a hostile environment for Jewish students or Israeli students or Black students or female or male or white or whatever else. That when the government funds are used as a basis for demanding the suppression of certain viewpoints, the suppression of political advocacy that expresses those viewpoints, however repugnant those viewpoints might be, that I think is a First Amendment violation. Some people say, well, this is a private university, so private universities can do what they want, consistent with the First Amendment. Yes, just as the insurance companies in Volokh could have cut off ties to NRA on their own, but that doesn't mean that the government can demand, on pain of loss of federal funds, can demand that universities impose such restrictions. The really hard question, though, comes up when the government is attaching certain conditions to a particular grant, and the conditions are germane to the execution of the grant. So imagine that the Trump administration says, look, here's a grant for research on youth problems or youth medical and psychological problems, but we do not want it to be used in order to promote gender transitioning. Or imagine the future Newsom or Harris administration, which says, here's a grant for youth medical and psychiatric problems, but we don't want it to be used to oppose gender transitioning. Like, if you want to do research on why gender transitioning is bad, or under the Trump administration is good, you can do it on your own, but just not using this grant. That seems pretty clear. Certainly outside the university, the government attaches these things all the time. The famous line from Rust v. Sullivan, which upheld something similar, is, to paraphrase a bit, the government can establish a national endowment for democracy without establishing a national endowment for communism or a national endowment for fascism, right? The government can say, here is money. We give it as grants to private entities, but we give it as grants to private entities to promote a particular mission. And if you want to promote a different mission, you can't do it with our money. So I do think the same would apply to universities. There's an argument that maybe academic freedom principles should preclude that. I doubt it. Again, just to give another example, imagine that the government wants to distribute funds, future administration, distribute funds for figuring out how to stop global warming. And there are, I think, perfectly credible people who say, we shouldn't be trying to stop global warming. Maybe it's too hard. Maybe it's too late. Maybe there are benefits to global warming. We should be trying to manage global warming and try to mitigate some of the harms of that. Perfectly plausible position. I have no idea how accurate that is, but plausible position. But I think the government could say, well, no, this money is for fighting global warming. If you want to talk about how we shouldn't fight global warming or should do something else instead of fighting global warming, this is not the grant for you, right? And maybe we don't have a grant for you. You go line up your own funds for that. So these end up being pretty difficult lines to draw. Thankfully, maybe that's the wrong term, but thankfully for First Amendment scholars examining this, at least as to some of the things that the Trump administration is doing, it isn't even really trying hard to draw those lines. Like, for example, with regard to the pressure that it is imposing on Harvard, I think it was essentially saying here's as a condition of this, you have to reform all of you reform certain departments and kind of prevent them from being used as a means for teaching certain ideas without any connection to particular grants. But in some situations, I think the Trump administration is saying, for example, we don't want to fund grants that promote DEI or some such, and there, I think it would have some authority to do that. Just again, as another administration may say, we only want to fund grants that promote DEI.
Thank you so much for all that and for flagging some of the case law involving funding restrictions, including the Rust v. Sullivan case, which, as you said, upheld a law that said Title X funds couldn't be used in programs where abortion is a method of family planning. And the Supreme Court said that it's not the case that the government can't make a value judgment favoring childbirth over abortion. and it can subsidize some family planning services without an obligation to subsidize those that promote or encourage abortion. Genevieve, a big, complicated topic, as Eugene helpfully reminds us, but what are some of the legal limitations and frameworks around threats to withdraw funds from universities based on content?
Okay, great. Thank you. So yes, a lot to talk about. I guess I'd like to separate out the two different questions that Eugene talked about. First, the use of anti-discrimination law and the threats about taking away funds for schools that violate Title VI and other federal civil rights laws, and then the separate question of funding. Although I guess I would just say in general that both, I agree with Eugene entirely, these are knotty questions. And I think both really raise, particularly as they're being used right now, really raise profound questions about how it is that we're structuring our system of free expression at the deepest level. Because a fundamental presumption of the First Amendment and what the First Amendment is, I think, intended to do in large part, as it's understood today, is to protect the independence of this kind of private sphere of thought and expression and association. And this private sphere, one of the important nodes in that private sphere are the private universities, just like the private broadcasters, and they're supposed to be independent of government control. One of the things I think we are really understanding today in all of these different ways is that, in fact, the federal government plays an enormous role in propping up these private universities and in giving benefits to broadcasters by the license, but in fact, just sort of in just monetary terms, the amount of federal dollars that are flowing to to both private and public universities is very significant, and that gives the government. It messes up what is supposed to be a clean separation between the public realm, the realm of government speech and government action, and that's the government, doing its thing, and then this private realm, which is supposed to be independent. And so I think there is this just profound question about whether or not our system of free expression actually is independent in the meaningful way that it is supposed to be when there is so much federal money and also state money flowing to these private institutions. This is one of the reasons why jawboning can be so successful. You have very strong carrots and you have very strong sticks when you're playing such an important role in the basic economic business model of these institutions. But of course, also, it's not obvious that the private market could replace this federal money. So the money is also doing an important service. So that's just a backdrop. I think this raises really important and significant questions that we should all be thinking about when we're trying to figure out, what is the separation between the public and the private spheres in our democracy. But just quickly, I think the question of anti-discrimination law is in some ways an easier one, although still a pretty thorny one, because I don't think that there is much disagreement that the government does have the ability under the spending clause to say, don't racially discriminate, don't discriminate on the basis of national origin. And if you do, we will cut off your federal funds, in part because courts have interpreted that to mean that discrimination is defined consistently with the First Amendment, which means discrimination isn't just saying discriminatory things. The First Amendment protects the ability of people to say racist things, non-racist things, that's completely protected. So the civil rights laws do not prohibit that speech. They prohibit conduct. The tricky thing is that speech can turn into conduct when it creates a hostile environment, as Eugene noted, when it is so outrageous and pervasive or severe that it makes it essentially like a shut door in your face, right? You can't go into the workplace because there are pictures of naked women everywhere and people are jeering. And as a woman, you're scared, you're intimidated. And so it's basically the same as the other workers shutting the door in your face. We would recognize that shutting of the door is conduct. And so courts have recognized that the speech acts that essentially have the same psychological effect can also be targeted under our anti-discrimination law. But where and how speech turns into a hostile environment, speech turns into conduct, is very tricky and unclear. And so this is why I think, in theory, it all makes a lot of sense, but in practice, it can be quite hard to patrol the line between, well, we're just going after discriminatory conduct or we're actually penalizing speech. And here, I think, we see again the question that I raised in my earlier comments about, well, how protective do we want to be of regulatory power? And how protective do we want to be of free speech interests? Because depending on your views, we could say, well, it's going to be tricky, we're not sure, but let's allow the Department of Education to go after schools when they think that, there's a lot of hostile stuff going on, but maybe some of it's speech, and maybe a court would sometimes find that some of that is protected. On the whole, though, we trust what the DOE is doing. We don't like racism. We don't like anti-Semitism. We don't like discrimination. Let's empower the DOE. I think that has been the approach taken under both the Biden administration and the Trump administration, where we saw the enforcement efforts of the Office of Civil Rights within the Department of Education. This is the entity that is responsible for enforcing Title VI and the federal civil rights laws on campus primarily. It employed very vague and loosey-goosey standards often. It gave guidance that was very unclear. And sometimes it's, as I've written before, including under Biden, in the face of the student protests, it looked like it was going after speech acts that I think should be understood as constitutionally protected. And so if you think that the real problem is race discrimination, and let's not be so worried about free speech on campus, that's okay. But I don't think that that is the correct attitude. So I think that there is a real problem with how agencies have been interpreting Title VI and the amount of leeway we give them to use the threat of the loss of federal funding to get universities to change how they regulate protest, which obviously implicates free speech rights, how they regulate speech on campus, and also under Trump, how they teach, how they organize admissions, a really expansive array of demands that I think clearly constitutes a kind of leveraging, unconstitutional leveraging on the part of the government when it comes to the First Amendment. But I do think even there's just really a tricky question about how much leeway do we want to give the enforcers of these anti-discrimination laws when there is this tricky question of what's discrimination and what's speech. I think the funding, so that's thorny, that's tricky, that's difficult. We got to figure that out. I think the question of funding is even more difficult and even more central to this question about what is the future of liberal democracy in a society where the federal government captures so much of our tax dollars and distributes it in this kind of, well, if you behave, I'll give it to you, and if you don't behave, I won't kind of manner on this discretionary basis. Because the doctrine is a compromise, I think. The court has reached a compromise position where it wants to give the government the power to fund speech that aligns with its ideological priorities in some cases, because it thinks, well, democracy requires the government to be able to fund its ideological projects. That's why we elect people to office, to promote particular viewpoints, not others. And they have to be able to then use their position to actually further those ideological projects. But at the same time, the courts have also recognized that the government funds an enormous amount of speech. And not all of that speech is supposed to be just about advancing its partisan or political agenda. And so there is this distinction the courts make, but it's a very messy one, and not I think, without vulnerability to game playing, between government speech that is funded by the government, but it's private entities who are actually doing the speaking that is supposed to advance the government point of view, and speech that is independent of that. When the government is funding speech that is supposed to represent its point of view, it can viewpoint discriminate. Just as Eugene says, it can say, we're only going to fund grants that are anti-global warming, not pro-global warming. We're only going to fund institutes that are pro-democracy. We don't have to fund pro-communist institutes. That's all fine, and there's no First Amendment problem there. When the government is funding speech that is supposed to be representing the voice and the view of the private speaker, not the government, it may not viewpoint discriminate. And in my view, I'm not sure whether Eugene agrees, I would be curious to hear, a huge amount of the grants that go to universities is private speech. We're funding a diversity of views. We're just funding research. The researchers, when I get, if I'm lucky, an NSF grant or an NIH grant, and then I publish a paper in a peer-reviewed journal, and it's got my name on it and my 12 co-authors, and I will thank the NSF or the NIH, but no one thinks that that is the government speaking. And if no one thinks that's the government speaking and the government isn't trying to use the funding to advance its ideological priorities, it's just trying to fund research to keep the US at the, in the forefront of technological development, then the government may not viewpoint discriminate. It may not say only pro-global warming and not anti-global warming, or only you can only research about a biological gender as we define it and not about transgender or whatever it may be. It cannot impose those constraints. And so I think there are very serious limits on what the government can do when it comes to funding speech. That said, it has so much power to decide whether or not to even create a grant program in the first place, or to decide broadly what it's about. So the government may not say, well, we're only going to fund speech that is worried about global warming, not speech that is not worried about global warming. But if it just creates a grant program that's about climate, given that we're living in 2025 when the Earth is getting hotter and the research communities largely agree that global warming is a thing, most of those grants are going to end up being about one thing and not the other, having one viewpoint and not the other. So even with these constraints that the doctrine imposes on the government's ability to fund, it still has an enormous amount of power to set research priorities simply by saying, well, this is the kind of subject matter we're going to fund and not another. And I think it is in knowing this, I think this explains why university administrators have been so unwilling in so many cases, even when I think the jawboning that they have been suffering at the hands of the Trump administration has been very dramatic, as we've seen with Colombia. I think they know that the government has so much power over the purse strings that they don't want to challenge that power and thereby deny all of their faculty the ability to get grants the next year because they're associated with a university that is now disfavored. And the doctrine is, I think, doing what it can to establish constraints on the government's ability to transform money into power over speech. But there are limits in what it is doing and perhaps also what it can do. And I think we should all be very concerned about what that means for the independence of universities and the research sector in general in the United States right now.
Thank you so much for those very thoughtful comments and introduction to the hard question of President Trump and the universities. We're nearly at time, and I think Eugene has the last word in this superb discussion. Eugene, you've written that President Trump's attempts to punish law firms based on their past litigation or advocacy against him may violate First Amendment rights to free speech and petition, as well as the Fifth and Sixth Amendment rights to fair trial, due process, and legal counsel. You can flick at that big and important question and tell us whether our discussion about jawboning casts any light on the questions of President Trump and the law firms, or bring together all the strands of this superb discussion as you think best.
Well, hard to bring together all the strands. They're complicated strands that they're quite different strands. I should also point out that while we started with jawboning in the sense of some threat of some unspecified, or I shouldn't say unspecified, some threat of future retaliation, we then moved on to the university context where there was basically a demand that people do something or else lose a particular grant. You might think it's connected to jawboning, but it's really just a much more basic, straightforward application of the principle that the government cannot punish you for your own First Amendment protected speech. Likewise, with regard to law firms, the government was trying to retaliate against the firms for their past support of their clients' Fifth and Sixth Amendment rights to trial and rights to counsel, but also for the law firms' exercise of their speech and petition clause rights. That's just a direct retaliation based on what the firms had done. I don't think we need to frame it as a jawboning matter. Courts so far, when firms have challenged it, courts have held the government's actions unconstitutional, and I think correctly so. Of course, some firms didn't challenge that, and that ties into Genevieve's points. There are often a lot of business pressure on various entities to go along, even with government actions that are pretty clearly unconstitutional. I think it's good that some firms were willing to challenge that, at least to set a good precedent going forward.
Thank you so much, Genevieve Lakier and Eugene Volokh, for a lightning round and a deep dive into the really important question of jawboning and the First Amendment. Genevieve, Eugene, thank you so much for joining.
Thank you.
Thank you.
This episode was produced by Bill Pollack and Griffin Ritchie. It was engineered by Bill Pollack. Research was provided by
Griffin Ritchie,
Anna Salvatore,
Trey Sullivan,
Tristan Worsham.
Friends, I'm so excited that my new book is coming out on October 21st. It's called The Pursuit of Liberty: How Hamilton versus Jefferson Ignited the Lasting Battle Over Power in America. I would love you to pre-order it on Amazon or elsewhere. And if you'd like, I would be honored to send you a book plate. So just write to me at jrosen@constitutioncenter.org. Tell me you've pre-ordered, and I will send you a signed book plate. And I can't wait to hear what you think of the book. Please also recommend the show to friends, colleagues, or anyone anywhere who's eager and determined in their commitment to enjoying a weekly dose of constitutional illumination and debate like the one we just heard. Please look out at the incredible America at 250 Civic Toolkit. And always remember, in addition to all that, the National Constitution Center is a private nonprofit. We rely on your generosity, passion, and engagement for all our programming. Please consider donating at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Jeffrey Rosen.